Next case is Reed versus Alpha Professional Tools.
I apologize.
That's all right.
I cannot believe that.
Just a little anecdote. Judge Thompson had warned everyone, turn your cell phones off and all electrical devices. 2 seconds later, his went off. So don't feel too bad.
I just walked outside and turned it off. That's why I apologize.
Welcome to my world. All right, you can begin when you're ready.
Thank you, ma'am. Ma'am, please forgive me. That's not a good way to start. My name is John Bales. I'm substituting for Sam Newman, who is my partner. He was sent to a trial, and unfortunately the judge would not give him protection to present the oral argument today, so I'm appearing. We have the pleasure of representing Travis Reed in this case. We are here on an appeal from an order of dismissing with prejudice action based on spoliation of evidence. The facts are rather simple. On November 13, 2002, Mr. Reed was using a grinder with a polishing wheel on it. The polishing wheel disintegrated, a piece of the wheel hit his eye, his left eye, and caused permanent blindness. An action was filed on October 26, 2005 for product liability and the normal counts against the appellees in this case. In October 9, 2006, at a case management conference, counsel for plaintiffs advised the court and opposing counsel that the grinder, the polishing wheel, and the safety glasses could not be found. And after intense investigation, it was discovered that after the time that there was a move by the law firm's office from Tampa to St. Petersburg, that the product disappeared. What's important, Judge, in this case is what happened, what we checked with. These items were locked on the second floor of the Tampa's office building. We lock up all our items, not only inside our office, but inside a locked room. That locked room was opened. The movers on July 29, 2006, moved the items to a locked room on the fourth floor of the new St. Petersburg office. Those items were locked in that room. There were extensive renovations still going on in the St. Petersburg office. The construction contractor asked us to open up the office. And
my understanding is that there is no allegation that this was intentionally done, and I think that was agreed upon by both sides. So through circumstances, it was lost, and that's where the trial court. That's what the trial court was left with, and that's what we are left with. Correct?
Yes, sir.
Is it critical as to what the movers' names were or what lockers they were in?
Sir, I think it's, with all due respect, I think it's important because the issues come down to spoliation of evidence and the sanctions that should be implemented because of that are three grounds. One, it was willful or a bad faith, the loss of the evidence. Is there incurable prejudice to the opposing party? And if there is a cure, what is that cure? That's the Fleury case, and in fact this court, even in their decision of Torres, talks about those issues. And the reason I was going into detail about the facts is to show that we, to this day, are surprised and shocked that it's not there. It's hard to believe it's not there, and this is an act that we don't know how to prevent. It was still remaining in our office. The standard that would be...
Counsel, I'll concede that in their answer brief, the appellee goes to great pains to make it look like a gross negligent conduct on your part, and that should be a part of the analysis. But I think, as from Judge Cohen's question, I think what we're more interested in is the question of what is the appropriate sanction here. what I see on one side is a vague allegation that the defendant can't defend, and on your part, an assertion that you can prove your case without this material. Could you address yourself to that issue?
Yes, ma'am. The bottom line, Judge, is that in this particular case, what our expert did prior to the disappearance of the equipment is he took detailed close-up photos of the grinder, of the wheel, and of the items. He then did a physical inspection, but no destructive or any physical testing of the equipment. He then based his opinion on the photographs he has and has given an assertion that the opposing side can look at the same photographs that he's given his opinion about and make a decision. Now, I will stipulate here that the assertion by our expert saying that a decision can be made just by the photographs needs to be ferreted out, just as much as the opposing side's expert says that there's no way they can make a decision. That's speculation, and I think some of the cases talk about just because you put an affidavit that says you can't decide, you can't render opinion, is speculation until you have a chance to look at the issues. So in this case, we think at a minimum the court should remand the case, this court should remand the case to trial court and say, give the parties the opportunity they ask for. And what we ask for is an opportunity to continue the hearing and allow at least 3 things to happen, and anything else that the appellees would like to do and appellates would come up. Number 1, this should be remanded to require, to allow the plaintiffs in this case to depose defendant's expert. And we wanted to find the defendant's expert, we want to provide the defendant's expert with the opinion of the plaintiff's expert. We want to provide them with the photographs and talk to them about it. We want to give defendant's expert the opportunity to review the photographs and everything else we have. And then we would like to depose the defendant's expert to discover if that's true. And then we believe that the court should be rendering a decision as draconian as this is. And this case is over, as it is right now. We believe that the appropriate remedy in this case, and if I'm going too far, but the appropriate remedy in this case is to say that, give an instruction at the jury, say that, and set it out, because we admit we don't have the product anymore.
Well, procedurally, I'm a little confused. On November the 7th, they filed their motion for dismissal, and they filed the affidavit. And a little bit over a month later, you file your response along with your several affidavits, and then the hearing is held on December the 13th. Wouldn't the time to take the deposition of the appellees have been sometime after November the 7th, but before the hearing?
We filed a motion with the court to ask them to allow us to take the steps. Quite frankly, with all due respect and understanding, we believed that we would find this. We searched everywhere. We went back to our old office and searched. The reason we took some time to respond because we didn't believe it. We didn't believe that it did not exist. We believed that at best we just had left it in the other office, or it was in one of the lawyer's office. At worst, we believed that it was accidentally taken by the contractor, and we went through a rigorous process of speaking to contractors, of having letters sent out to the subcontractors. We had it's not in the record. We took a lot of other actions to try to do it. That's the reason it took as long as we did to respond. However, we did ask before the time of the ruling, and the judge gave us time at the time of the hearing to say, okay, let me think about it and what I'm going to do. We asked to have a continuance before there was a ruling so that we could have the opportunity to take the 3 steps that I had suggested here today.
So it's your position that you can prove your case based on the photographs only?
Most certainly.
Can you prove your case based on the photographs only without the testimony of your expert's physical examination?
We believe that can be done, and we believe our expert has given an affidavit stating such. And we believe that the defendant's expert can do the same thing. In fact, the defendant's expert has a real advantage over us. The defendants do. They're the manufacturer and the sales of the wheel, so they have a lot more information. They know about past losses according to the wheel. They know we have the invoice of it. We have photos of it. They can present a lot more evidence than we can. The person that's been prejudiced the most is the plaintiffs in this case, not the defendants. However, by dismissing the action with prejudice, we were out of the ballgame.
Discuss with me a little bit, if you will, the application of the Torres case. Opposing counsel says Torres controls. Trial judge relied on Torres. Does Torres control our analysis of this case?
I think Torres is, it's up to this court to decide whether it controls, but I think there's a distinguishing factors between Torres and this case, and if I may walk through Torres, I'll go through it.
It's your time. Use it as you please.
Yes, thank you, ma'am. In Torres' case, and I'll quote from the court, said, in that case, which involved a vacuum cleaner that was...
You understand Judge Griffin was on that panel.
I'll be very careful. Thank you. In that case, it says, and quote, that the plaintiff kept no records, packaging, or warranty materials that came with the vacuum, and because the photographs of the vacuum she did not maintain do not show the maker model number of the machine, or even enough of the vacuum to make any reasonable identification. It is only her unchallenged testimony that the vacuum at issue was designed or manufactured by defendant, which ties defendant to the case. The court then took these facts and says, defendant has been denied the opportunity to determine the actual age of the particular vacuum, its length of service, the severity of its use, its state of repair, and whether it was subjected to any abnormal operation, and it was denied this opportunity because of the negligence of plaintiff through her lawyer. Let me distinguish...
If you said before that you could prove your case based on the pictures that were taken and without the, reliance on expert testimony, is that basically...
No, sir, I didn't say we would need expert. I believe we'd need expert testimony as well.
Do you have to rely on the Greco inference to prove your case in any way, or are you able to do it without that inference?
The answer is, Judge, I'm not sure. I think we might, but I would like to have the opportunity to depose defendant's expert and to get them the information to decide. I'm not sure.
You don't know whether you'd be able to prove your case without application of the Greco inference or not?
Well, I think we can.
You think you can?
Yes.
How would you do that? You got pictures?
Yes.
And you're going to have an expert testify from the pictures?
Yes.
And that's it?
Yes. He says in his affidavit that he can testify from the photographs themselves showing up. By the way, there's more than that. And I was going to say there's the invoice. It's the product was less than a month old at the time it was used. And we have
have you alleged strict liability? Have you alleged warranty? What is the basis of your cause of action here?
We have the typical product liability, the three.
That can come in various forms. Warranty, it can come in strict liability, negligence. What did you plead all of that?
Yes, sir.
All right.
Yes, sir, we did. In the Torres, let me give the distinguishing factors, if I may. Foremost, there was no dispute that the make and model of the polishing wheel in question. Number two, plaintiff has detailed photographs of the polishing wheel, a sales invoice, and multiple advertisements from defendant's catalog. Number three, defendants can easily determine the age and length of service of the polishing wheel through the invoices and photographs. Four, in addition, defendants can ascertain the state of repair of the polishing wheel through the photographs and deposition cross-examination of plaintiff and plaintiff's experts. And number five, defendants can discover any abnormal operation of the polishing wheel through depositions, cross-examination of plaintiff, along with simple investigation of plaintiff's work practices through interviews or depositions of former co-workers and supervisors, which would have been done in the case in any event. The addition of this, we understand that there's been prejudice, and this is material evidence to this case. We don't deny that. What we're asking the court is that the prejudice is not so extreme to defendants that the case should be dismissed. We assert that the prejudice is just as much to the plaintiffs as the defendants, and it creates another level playing field. We are asking for Mr. Reed to have his day in court. At a minimum, we're asking the court to remand the case and allow us to further develop the concept that this case can be tried on a level playing field to make a decision. I understand the Torres case. I understand the court relied on that. However, our belief is that the trial court's decision, the abuse of discretion, is they turned the Torres case into a strict liability cause of action. Strict liability being the fact that the evidence was lost There's no way that the defendant, no way, that's what the case say, no way the defendant can present a defense. And I believe in this case that there can be, and I don't believe it's strict liability. I believe it's a weighing standard with the scales of how it balances out. If I may, I'll reserve the remaining time for rebuttal.
I'll be fine.
Good morning.
Counsel,
Please report.
let me ask you to start with where he left off, because it's a concern that I have too. Based on my reading of your brief, essentially what you're arguing is that as a matter of law, when the defendant is deprived of the opportunity for obtaining information that might be valuable to the defense because the item has been lost, the plaintiff must be deprived of his cause of action.
Yes, and
That's
that is our
basically
position.
your argument.
That is our
So
position.
whether he lost it intentionally or lost it negligently, when it's gone, the defendant gets the benefit of that.
Well, Judge Griffin, and I understand that is your concern. I did read your dissent in Torres, and it did touch on those concerns as well. The thing that Reed is trying to blur here is the distinction between intent and fault. Now, there may not have been intent, willful intent, to lose this item, but there is a distinction here because of the fault involved. They are clearly at fault for losing this product. They didn't secure it. If they secured it properly, we would still have it. They obviously didn't secure this properly, and there has to be a distinction between the non-spoliator and the spoliator here. And that is the way you have to look at it from these cases. And the cases, I think, all do seem to bear this out. When you look at cases that keep the litigation going, more often than not, it is when there is no fault involved. When you have fault, as in the Torres case. In the Torres case, the vacuum cleaner was left in the plaintiff's counsel's garage and it was thrown out in the trash. Here you have this case where plaintiff's counsel left the evidence in the hallway. This was our only evidence in this case, and as you learned in our brief, that it's more than just the grinding wheel here. It's the grinding wheel, the grinder, and the glasses. They all are in conjunction with each other because they were all formed in the same act here. And the fact is, we are completely deprived of our ability to defend this case. The fact is, we have filed an affidavit from our expert. It was a 5-page affidavit. It set forth Ms. Yaek's education, training, qualifications. It set out the facts of this case. It set out the facts of the spoliation. And it also set forth the opinion of why we cannot defend this case. There are so many things that we're forever deprived of looking at the evidence in this case. We're forever deprived of looking at the grinding wheel. We can't examine it through photographs for wear and tear. We can't examine it for fracture patterns. We can't examine the fracture initiation site. We can't examine the chemical composition. We can't examine the attachment site where attached to the spindle of the grinder. We can't examine it for any foreign material that may have been on that grinding wheel. We can't examine it for abuse, misuse.
Well, suppose, just hypothetically, at the moment the accident occurred, all of these items went up in smoke. They just disappeared.
Well, then,
There's no fault. They disappeared. They no longer exist. The plaintiff has his photographs. You have Mrs. Yaek, or whatever her name is.
Yaek.
And so if he wants to proceed on the basis of the photographs to show that there is a defect, why can't you, on the basis of the photographs, defend?
well, I think that would be a distinction between what actually happened here and a mythical case here, and I think then if that were the case, plaintiff would be attempting to use the Cassisi inference, and I think that
Well, assume he's not. He says he can prove his case without the Cassisi inference.
Well,
If
looking
this were a Cassisi inference case, I concede we're controlled by the Torres case, much as I loathe the opinion. But this, he says it's not a Cassisi case.
Well, there also, you have to look at the record evidence here. And the record evidence is that we filed the affidavit with our opinions that we could not defend this case under these facts.
But that's not the issue. The issue is whether he can prosecute it.
He hasn't provided any record evidence that he can. There's been no expert testimony that he can actually provide an expert opinion. If you look at the affidavit,
isn't that what distinguishes this case from the Torres case? In Torres, there was nothing. There were no photographs. There really wasn't much of anything other than, I call it the Greco inference. And the court said you can't use that. You know, there were no photographs. There was really no proof, and that's not sufficient. But here we have photographs. We've got some other evidence that they could present, which may be a distinguishing feature, which may take it out of the Torres holding and put it somewhere else.
I don't believe that we could defend, and I believe that basically from looking at all of the evidence in this case and looking at...
You represent the manufacturer?
I actually represent the plaintiff never sued the manufacturer.
Who do you represent?
I represent Alpha Tool and Benno Gunlight Company. We're actually the distributors, and they distributed to a retailer who the facts are a little unclear, but it appears that the retailer then sold it to Mr. Reed's employer.
Well, let me get back to my question about the Torres. Didn't Torres basically say that because there was no other evidence, you can't solely rely on the Greco inference in a spoliation case? But here it's a little bit different in that they've got pictures and they've got some other evidence and that they can present.
I think the pictures are unclear in this case, and you're talking about a product that's not even a passive product here, like a vacuum cleaner. You're talking about an active product here.
But why wouldn't it be appropriate to give them an opportunity to see if they can prove their case based on the evidence that they've got here that wasn't present in the Torres case?
Well, the fact of the matter is, in this case, we have, one, I don't think you can ignore the fact of the fault in this case. I don't think it can be ignored. Whether the intent, I will agree, is irrelevant here, but I don't think you can ignore the fault.
If we take away the Torres case and say it doesn't apply, then where are you?
Well, I think if we take away the Torres case, there's still cases here. There's the DeLong case, DeLong versus ATOP out of the 3rd. There's the Sponko versus Allcover case out of the 3rd as well. I think that you look to these cases, and they virtually they apply the same reasoning as the Torres majority that you were involved in, Judge Sawai. They apply that same reasoning to basically you have to take the focus off of the harm of the spoliator, and you have to look at the non-spoliator of the evidence and look at the harm that is done, the prejudice that is done to the non-spoliator here as to even the playing field. It's all about fairness here. And with all due respect...
Well, but don't you have an even playing field if he only relies on the photos and you only rely on the photos?
Well, I don't think it's an even playing field.
You're not talking about prejudice, you're talking about a lost opportunity.
Well, it's a lost opportunity, but it's about fairness. They're basically coming in here and saying, we have photographs of this purported product, and you have to believe that this purported product was used in this incident, and it caused injury to my client, and now we're suing you, and you have to basically take our word that this is the product, when there are so many other additional
But you have to do that
factors.
anyway. I mean, nobody else is going to know whether they used the product or not other than the person that used it, and I assume that person is going to testify I used this product, and here's a picture of it. So what difference does that make?
Well, certainly. I mean, that is incorporated into any case. But the fact is, in this case, you have, it's inherent in this product that we have to look at other factors. We have to look at these fracture initiation sites. We have to look at the origin of where this fracture allegedly occurred. We have to look at whether the product was abused or misused. That's another great distinction here. This is an active product. This is a product that required operation, and it was worked in conjunction, was used in conjunction with a grinding wheel here. The grinding wheel had the spindle. We had to look at the grinder itself. Excuse me, not grinding wheel. If the grinder itself wasn't lost as well, we'd be able to see if the spindle was possibly tilted. If that spindle was possibly tilted and the grinding wheel was not spinning in a symmetrical manner, that could have had a great deal to do with what happened here. Also,
Is that not in the photographs?
I don't believe that is in the photographs, the grinding wheel. Well, actually, there may be a one photograph of the grinding wheel, the grinder, but the fact is it's not an examination that we could use in our defense in this case. The fact is we did submit the testimony of our expert who looked at the evidence in this case, looked at the available evidence in this case, and determined that based on her education, training, and experience, that she would not be able to give an opinion to defend us in this case. And there has been no corresponding affidavit from the plaintiff rebutting this testimony. And Judge Griffin, you brought up a very good point before. We filed the affidavit November 5th or November 6th. We filed Ms. Yag's affidavit. The hearing, the timeline here is very important because then you have December 13, we have our motion to dismiss hearing. There is no request to take any depositions of our expert to test her opinions, to find out more, to probe it, as counsel was stating earlier. We get all the way 2 months after the motion to dismiss hearing. 2 months later, the first week of February, just prior to the judge issuing her order in this case, the plaintiff then files a motion to continue, and it's the first time there is any request to ever take a deposition. And it's actually kind of interesting because in their motion to continue, in their request, they request the continuance so we can take the deposition of their expert. They don't even ask for the deposition of our expert at that time, if you look at the motion. So it is kind of interesting, that, and it is a point that you brought up, Judge, that I thought was very important because that timeline is very important in this case. Now, we are here on an abuse of discretion standard that Judge Thomas, when she issued the order, she looked at the Torres case, she looked at the DeLong case, she looked at the Sponko case, she looked at all of the factors involved in this case, she set forth an order that detailed the facts, and she set forth the law, and it was in her discretion to issue this order. And we believe that reversing on this order would also be tantamount to directing verdict against our client due to the prejudice that we have suffered. And I know that by the smile, Judge Griffin, you're doubting that, but I believe that from the testimony that Jennifer Yayek in her affidavit has set forth, I believe that she has laid out, and if we can go through, that she examined the evidence in this case, examined the facts, and she did find in paragraph 7 of the affidavit that the destruction of the evidence above without any notice to alpha defendants prevents them from fully defending this litigation and completely addressing the defect allegations. And as she goes on with all of her opinions in this case, there's not one shred of evidence contrary to her testimony. If you look at the affidavit from Mr. Saluga that is in the record at page 190 to 193, instead of a 5-page affidavit, we have a half-page affidavit that is 6 paragraphs, and his opinions are, I quote, "I have formed some opinions related to the fracture of the grinding wheel." If there ever was a time when you know you're facing dismissal of an action, if there ever was a time to set forth your opinions that you could prosecute this action, one would think it would be before the order is entered, instead of acting with disbelief that you can't find the product, that you're not believing that the product is lost. You have to set forth you have to put up your fight, and that's the time to do it. I think that there are other portions of the timeline in this case that are important. If you look back to March of 2006, that's when we had our first request for an inspection in this case. March the 6th, 2006, we have our first request for inspection. We had filed our answers a few months earlier, served discovery, then we send our request for inspection. We never get to see this product. We are denied by the plaintiff at every avenue. And finally, what actually leads to the hearing on October 9th, there's a lot that was kind of left out in there, but between our request for inspection in March and this hearing on October 9th, there were numerous requests to get this product inspected. We could never do it, and we had to file the motion to compel. We go to the hearing, we had a motion to preserve evidence, and when we go to the hearing, as you've read in the transcript, Mr. Newman, at my motion, basically cut me off and said, "Judge, I think I have some information that could basically remove the need for this hearing." We lost the evidence. So basically, we were trying at every avenue to look at this evidence as well, and we still couldn't get it. And then only when we finally get plaintiff in front of the judge do we finally learn that this evidence was lost. And I think that we can't lose sight that the focus here and the focus of the case law is that it's the prejudice to the non-spoliating party, and that's my clients. That's Alpha here. That it is the appellants here, they are trying the strategy to make themselves appear blameless here. And they're clearly, even though, as stated, intent is irrelevant, fault is clearly relevant in this case. And Judge Griffin, you used earlier that we were trying to make it look like gross negligence here, and I believe it was. I believe it was. You can't leave evidence laying out in a hallway when it's the only evidence involved in a case. It's like repairing a vault and leaving bags of money in a hallway. A bank couldn't do that. An attorney is the safeguard and has a duty, once that litigation starts, at the very least, once the litigation starts, that attorney has a duty to protect that evidence. And in this case, Reed's attorney did not protect it. Now, the trial court analyzed the facts in the law, acted well within its discretion according to the law and using the Torres case. And the expert testimony in this case is overwhelming in favor of our clients. There was no corresponding testimony to rebut our affidavit. Our testimony by our expert demonstrated a complete inability to defend as a result of being forever deprived of all of the evidence in this case. And it's not just the grinding wheel, it's the grinder, and it's the glasses as well. We, as the distributors, would have been entitled to indemnity from the manufacturer, but we're forever deprived of this evidence. We're also forever deprived of learning the manufacturer of the safety glasses in this case, or to see how they fit, to find out how he was wearing safety glasses and still was injured in this case. We're forever deprived of that. We're forever deprived of filing a third-party action against the manufacturer of the grinder to find out there was some defect in the grinder in the way the grinding wheel was seated. We are forever deprived that due to the fact that this evidence was all lost. This is not punitive. This is not a punitive measure. This is a remedial measure. And it's the only fair measure in this case. And that we ask that you affirm the trial court's order. Thank you.
Thank you, Counsel.
May it please the court. First of all, let me clarify the record. This evidence was never not in a locked office. It was in the confines of our office. It was locked within our office. Just like most lawyers may keep evidence in their particular office that is connected to other offices, we didn't put it in a public hallway. It was a hallway next to the lawyer's office where evidence by many law firms is put. It was always secured, in our opinion. He is correct. We are still, to this day, driving over here today, we're still surprised that that evidence is not there. But to impugn our reputation over that doesn't seem reasonable. Just a
Let me ask you about something else that I meant to ask you about to begin with that was brought up during opposing counsel's argument. And that is, as I understand it, the move was in July of '06.
That's correct. July 29th.
But you had already had a request to produce these materials, and back in March, there had been a motion to compel inspection of the evidence. What was that all about?
Judge, we were having the evidence reviewed by our expert, and quite frankly, I am substitute counsel on that issue. I don't know the exact answer. Here's what I believe, and I'm hesitant to go forward. As I recall, it was in the hands of our expert, but I don't know that for sure, and I don't want to make that statement. There is no way.
Well, I don't know if there's a Florida case on it, but I know there are at least a couple federal cases where the court says, you know, if you had acted as you were supposed to have acted before it was lost, then the burden of that falls on you. In other words, if you should have produced this stuff back in March, the fact that you lost it in July is your problem.
Judge, with all due respect, that issue was not raised in the answer brief. I was brought in this case at the last minute because my opposing counsel, my co-counsel had to go to a trial. I didn't know I was going to address that issue. I do believe there are extenuating circumstances, and I apologize for not being able to answer that completely for you. I do not believe that it's as simple as the opposing counsel is making a stand that we did not produce it. Every products liability case, we have to produce the evidence. There would be no reason not to produce it. It was July 29th. We did not believe on July 29th, or even a month or two after that, that evidence would not be found. We did extensive investigations. We had different attorneys as well as staff search for it, go back to the old office. We filed a police report. We had letters sent out to the contractor. We believed that it would be found. It's still surprising. Before this hearing, we went and checked again. Judge, there was no malice or intent. In this case, I asked the court to rise above what was been raised by opposing counsel trying to denigrate what was happening in the case, which wasn't raised to the trial court, which wasn't raised in the answer brief, and it's being raised here because it wasn't going well in Torres' case. Let me give you a couple quotes from opposing counsel at the October 9th hearing. He says, "I don't believe anything here was purposefully." It also said, opposing counsel, obviously, the loss of the evidence, damages their case far more than it would damage ours. All of our responses have been in good faith, believing that we are working with opposing counsel. Opposing counsel understands the severity of this. We believe this is punitive to eliminate the basis for this case. There are photographs. They do have warranties and instructions. This is all available to them, and it's our case whether we can put it on. If we can't prove our case, so be it, but we should be allowed to prove our case.
What about opposing counsel's point that the February 2nd filing of your expert's affidavit was not only too late, but way too little?
I absolutely disagree with that, especially in the sense the reason we didn't go into great detail is we thought we were putting it out there and saying there are issues that need to be addressed. And we put it out, instead of having a long recitation by the expert, we thought that would be inappropriate. We wanted to divide.
What did your expert say in his affidavit?
Basically, the expert says that he reviewed,
Can you read it to me?
I have to go get it.
Can you get it?
Yes, ma'am. The perfunctory language before me, the undersigned. I have personal knowledge of the matters. And number 2, I was retained by counsel for plaintiff Travis Reed to perform an inspection of a Makita grinder, a grinding wheel from the grinder, and a pair of safety goggles, and render opinion as to the cause of the fracture of the grinding wheel. During the course of my usual inspection, detailed close-up photographs were taken of these items. I did not perform any testing of the incident materials out of which these items were manufactured. I have formed some opinions relating to the fracture of the grinding wheel. All the opinions I have reached are based on analysis, inspection, and testing exemplar grinding wheels and visual inspection of the incident items, and can be sustained entirely by the photographs that were taken without items being physically present. And that was important. It was the photographs, substantially entirely by the photographs. We didn't file a long affidavit because we thought it was unreasonable to put that before the court without giving the opposing side the opportunity to deposing our defendant, deposing our expert. We thought that was reasonable.
Is your theory a manufacturing or a design defect?
Manufacturing or design. Manufacturing.
If you don't know, that's okay.
I'm not sure. I think it's a little of both. And I apologize
Counsel, you've
for that.
exhausted your time, or one of us has exhausted your time. Thank you.
Thank you.